Gandhi. The respondent Mandela is represented by my learned friends opposite, Hussefa Adamali and Chris Browand. This is a hearing of the appeal of Gandhi and Mandela. Would your lordship like to be reminded of the facts of the case?
No, thank you, Counsel.
I am obliged. The appellant will submit that the postal rule does not apply in this case, and therefore no contract was formed, and that Gandhi is entitled to damages because of misrepresentation. My lord, before I move on to the first of my submissions, may I confirm that your lordship has received a copy of the appellant's skeleton argument and the bundle of authorities?
Counsel, yes, I'm obliged, thank you.
My lord, the appellant Gandhi submits that there was not a valid contract until acceptance was received. He will appeal this on 3 grounds. Firstly, that the postal rule does not apply as this situation can be clearly distinguished from other cases. Acceptance should be a final and unqualified expression of assent to the terms of the offer. It is not disputed that Mandela attempted to accept the offer. However, his acceptance should not be applied in this case. Mandela should have accepted the offer using the same method as the offer was made.
Counsel, can I pause you there for a moment? Your issue about the correct method of responding to the offer, my understanding, forgive me if I've got this wrong, is that a telephone number was included in the advertisement.
Yes.
Is this your point, that the telephone was the correct way of answering?
Yeah, I'm obliged, Lord. In this situation, previous contact had been done through telephone, and when Gandhi attempted to revoke the offer, this was also done by telephone. In fact, there was nothing within the offer or the previous negotiations that would have given Gandhi the impression that post would have been used. In fact, a reasonable man would have assumed that the telephone would have been used.
Yes, thank you, Counsel.
Okay. My learned friends opposite will argue that according to the postal rule, there was a valid contract between Gandhi and Mandela. The postal rule is an exception to the general rule that acceptance must be communicated to the offerer. However, despite this, the fact that the postal rule has still got precedence in UK law, it has received many criticisms, with Triton describing it as arbitrary and should not be applied in this case. In reality, it would suffice for English law to say that acceptance takes place when acceptance is received by or communicated to the offerer. This position is adopted under many other systems, including the Vienna Convention on Contracts, International Sales of Goods, the UNIDROIT Principles on International Commercial Contracts, and the Principles of European Contract Law. However, we can also clearly distinguish this case from the leading postal rule case of Adams and Lindsell, which is reported in volume 106 of the English Reports 1818 at page 280. This will be used to support the respondent's argument. In the case of Adams and Lindsell, the previous contacts had been done through the postal service. In this situation, all previous contacts had been done through telephone. This moves me on to my second point. The rest of the dealing had been done by telephone, so it would not be unreasonable for Gandhi to have assumed that acceptance would also be by telephone. The parties need to have contemplated that post would have been used as a method of acceptance. This follows the case of Henthorne and Fraser, which your lordship will find at tab 1, page 7 of your bundle.
Where should I be looking?
At the highlighted area.
The first highlighted section.
First and second.
Thank you, Counsel.
This case clearly states that parties should contemplate whether or not post would be used as a method of acceptance. In this case, prior communication had been performed fully by telephone, so it would not be unreasonable to suggest that Gandhi assumed that Mandela's acceptance would be done through telephone as well. This leads me on to my third point.
Counsel, pausing there. There is a distinction, Counsel, between something being reasonable and something being unforeseen. It's not completely unreasonable, Counsel, to suggest that someone might reply to an advertisement in a newspaper in writing. Is that the submission from the appellant, that that is an unreasonable, unforeseeable restriction?
Your Lordship, we submit that previous contacts had been done by telephone. Gandhi had phoned Mandela in order to make an offer as to the advertisement within the paper. When he attempted to revoke his offer, he also used telephone as his method of communication. In previous cases regarding the postal rule, it was clearly held that previous contact had been through the post, or that a reasonable man would have assumed it. Personally, I feel that if I had previously contacted someone through the telephone, then this is how I would expect them to contact me. This appellant therefore submits that the postal rule should not be applied here. It would be absurd to apply it where Gandhi had clearly wanted to revoke his offer and had taken reasonable steps to do so. Gandhi did not realise that acceptance would be made by post, as Mandela did not express that this is how he would do it. Just because Gandhi did not expressly state that post should not be used, this does not make him irresponsible. He may simply have assumed, which would not have been unreasonable in the circumstances, that Mandela would accept by telephone, as this is how previous conduct had been performed. Just because Mandela was on holiday, this does not mean that he could not have used the telephone to accept the offer. I'm sure your Lordship will agree, in today's society of modern technology, it would not be unreasonable to assume that someone, whether they are travelling abroad or within the UK, would actually communicate through telephone, particularly when previous contact had been done in this way. I refer your Lordship to the case of Howe Securities Limited and Hughes, which you will find at tab 2, page 19 of your bundle. If you'd like to look at the highlighted evidence. In this case, several exceptions to the postal rule were presented. Firstly, following Henthorne, it was argued that the parties must have contemplated that post would have been used. Also, the rule does not apply if it would lead to manifest absurdity or inconvenience. This means that having regard to all the circumstances, including the subject matter being considered, the rule does not apply where the parties cannot have intended that there should be a binding agreement until the acceptance has been communicated to the other. The same principle can be applied here, as Gandhi did not accept that acceptance would be made by post, and it would not be unreasonable to suggest that either party did not view the contract formed until Gandhi had read the acceptance. It was...
Thank you, Counsel. This idea of producing manifest inconvenience, this manifest inconvenience seems to be levelled highly on the appellant in this case. So it's not simply the appellant attempting to escape from a bad bargain, make a remedy for his inability to manage his own financial affairs. Who should this manifest inconvenience affect?
Your Lordship, this inconvenience affects both the appellant and the respondent in this matter. It also affects the ordinary man. On a daily basis, people respond to small ads, both through newspapers and through the internet. I would ask your Lordship to imagine a situation where he is attempting to purchase an item through one of these small ads. You may view several adverts, and you may send an offer to several people, offering them a lower amount. As an ordinary man, you would not feel bound by these offers. It would be absurd if 3 of those people replied and said that they accepted your offer, if you were to be bound into all 3 of these contracts. It would lead to absurdity if your Lordship was to conclude that everyone who makes these offers on an ordinary daily situation is bound to a rule that they simply do not know exists.
Yes, thank you, Counsel.
Overemphasis, your Lordship, should not be placed on the precise moment that a contract is concluded. The contract in this case did not have a clearly defined duration and evolved as part of negotiations. Putting a rigid offer and acceptance model onto this case does not capture the dynamic nature of such contracts and negotiations between parties. The moment at which the contract was formed should not be overemphasised. The contract formed had a degree of flexibility built into the negotiating format. My Lord, in conclusion, the appellant Gandhi submits that a valid contract was not formed between himself and Mandela, as acceptance was never received and the postal roll should not be applied in this case. Unless I can be of further assistance to your Lordship, those are my submissions.
No, thank you, Counsel. I apologize.
If it pleases your Lordship, my name is Jose Fazimali. I'm appearing on behalf of Mr. Mandela. Your Lordship, it is a general rule that a postal acceptance takes effect when the letter of acceptance is posted. not when it is received, as the counsel for the appellant has argued. Your Lordship, I would like to respond to the leading counsel's arguments that the method of acceptance, which is posting, should have been under contemplation. I would like to invite the court towards the case of Henton and Fraser, reported in the Chancery Division on the yellow tab.
Yes, thank you, Counsel.
Your Lordship, it was held that when the circumstances under which an offer is made are such that it must have been within the contemplation of the parties, that according to the ordinary usages of mankind, post might be used as a means of communicating the acceptance of it. The acceptance is complete as soon as it is posted. Held that in the present case, as the parties lived in different towns, an acceptance by post must have been within their contemplation, although the offer was not made by post. Your Lordship, it is pretty clear from this authority that if the offerer and the offeree are in different places, then posting as a method of acceptance should be under contemplation. And as Mr. Mandela had clearly told Mr. Gandhi that he is traveling, he should not be in the city where he was previously. So, it is submitted, my Lord, that the method of acceptance as post would have been under contemplation. Your Lordship, the leading counsel has argued that no previous communication had been made through post, and the only communication which was going on between Mr. Mandela and Mr. Gandhi was through telephone. I would like to submit, Your Lordship, that Mr. Gandhi contacted Mr. Mandela through telephone, and Mr. Mandela never contacted Mr. Gandhi through telephone beforehand. So there is no evidence that Mr. Mandela used to contacting parties through telephone. He being a retired old man, my Lordship, it is submitted that he might not be that technologically savvy.
Counsel, without going beyond the scope of the facts in the present case, to what extent would the contemplation of the use of telephone only affect your own submissions?
Your Lordship, this is exactly my second point of submission, Your Lordship.
So if you wouldn't mind dealing with it now, the second point.
I would like to invite the court towards the case of Holwell Securities and Hughes.
Yes.
Your Lordship, if Mr. Gandhi wanted the acceptance to be communicated by telephone, he should have clearly stated that he wanted it that way. Your Lordship, I would like to read from the judgment of Mr. Lord Justice Lawton.
Yes.
Does the rule apply in all cases where one party makes an offer which both he and the person with whom he was dealing must have expected the post to be used as means of accepting it? In my judgment, it does not. Your Lordship, Mr. Lord Justice Lawton, after expressing the general rule, goes on towards the exceptions of the general rule. He says, at first, it does not apply when the express terms of the offer specify that the acceptance must reach the offerer. Here, Mr. Gandhi never said that the acceptance should be through telephone. It was his duty to protect himself. As Mr. Lord Justice Lawton has said, the public nowadays are familiar with this exception to the general rule through the handling of football pool coupons. So it was not Mr. Mandela's duty to tell Mr. Gandhi that he will be sending the acceptance through post or by any other means. Rather, it was Mr. Gandhi's duty to clearly say the method of acceptance. Your Lordship, Mr. Lord Justice Lawton then moves on to the second exception to the general rule. He says, secondly, it probably does not operate if its application would produce manifest inconvenience and absurdity.
Yes.
This was one of the main arguments of the leading counsel for the appellant. Your Lordship, then Mr. Lord Justice Lawton provides two examples where there would be inconvenience and absurdity. The first example was of a stockbroker who is holding shares to the orders of his client. Would a stockbroker be liable in damages because he did not sell in a falling market in accordance with the instructions in the letter which was posted but never received? Here, Your Lordship, it is submitted that there was a very narrow time constraint. Stock in a market where the prices of the shares are falling.
I'm familiar with the point raised. To what extent is that helpful when dealing with an advertisement in a local paper for a bike, which my understanding of push bicycles is that they have a standard value which doesn't move beyond the course of years.
Your Lordship, my point over here is the time constraint, which is Mr. Mandela has said to Mr. Gandhi that he will be sending the acceptance within a week, and accordingly he sent the acceptance on Tuesday, like 3 days after the offer was made. So it was within the time frame. There was no time constraint over here, Your Lordship.
Yes, thank you, Counsel.
Your Lordship, it is further submitted that the appellant mentioned that he had tried to withdraw the offer by telephone. Your Lordship, it is submitted that in the case of Adams and Linsell, that the withdrawal, in that case, the withdrawal was sent by post. But it was sent even before the acceptance was actually posted. And it was held in that case that withdrawal was not effective until it was brought to the mind of the person to whom the offer was made. Your Lordship, it is submitted that in this case, neither the withdrawal was brought to the mind of the offeree, nor it was posted or it was communicated before the acceptance has been posted. Your Lordship, in conclusion, I would like to submit that it is clearly established legal authority that postal rule is valid, and accordingly I invite the court towards specific performance of this contract. Unless I can be of any further assistance, Your Lordship.
No, thank you, Counsel. That's all right.
May it please Your Lordships, I am Stanley Mead, Junior Counsel of the Appellants Gandhi. My learned counsel has already addressed Your Lordship in the first round of appeal, so I will now address Your Lordship in the second round of appeal.
Yes.
My submissions will therefore deal with Mr. Gandhi, whether Mr. Gandhi is entitled to damages because of this misrepresentation. My Lord, the following submissions will be in the order that, firstly, Mandela made a false statement of fact, which does in fact constitute a negligent misrepresentation. Secondly, there was a negligent misrepresentation which involves a statement made honestly, but without grounds for reasonable belief. And thirdly, under Section 2, subsection 1 of the Misrepresentation Act 1967, a statement that is made without reasonable grounds to believe that the statement is true is actionable misrepresentation which will make the representative liable. To proceed with my first submission, my Lord.
Please, Counsel.
A misrepresentation can be defined as an unambiguous false statement of fact, which is addressed to the party misled and which induces the party to enter into a contract. First of all, the misrepresentation must have been unambiguous and clear. In this case, Mandela expressly stated in his advert that the bicycle was a limited edition Roadmaster 2000 on offer for £500. Secondly, the misrepresentation must have been false. Since we have all been enlightened that all limited edition bikes are red, we can safely assume that this blue bicycle was not in fact a limited edition.
Councillor, my understanding is that's not an issue.
I am obliged. Thirdly, there must have been a statement. There's no doubt that in this case, a statement was made in the form of written communication in the newspaper. Assuming there was a statement, it does not necessarily have to be a term in the contract, and it will suffice that it induced my client, Gandhi, into entering into the contract. In the case of Avon Insurance Limited against Swire Fraser Limited, which can be found in Volume 1 of the All England Reports, year 2000, page 573, which at the bundle, my lord, is page 26 for you.
Yes, thank you.
Rix J declared the test of causation is inducement, that the misrepresentation need not be the sole or decisive inducement, as long as it materially contributed to the decision of the representee to enter into the contract, and that a misrepresentation, for instance, one likely to influence a reasonable man, sets up a presumption or inference that the claimant has been induced.
Yes.
In conclusion to my first submission, my lord, Mandela made a false statement of fact. To proceed in my second submission, there was a negligent misrepresentation which involves a statement made honestly, but without grounds for reasonable belief. In the case of Headley Byrne and Co. Limited against Heller Partners, which can be found in the House of Lords Appeal case, page 465, year 1964. In the bundle, my lord, you can find at page 88.
Yes, I have that, thank you.
I am obliged. In this case, it was established under common law, where a person who has or professes to have special knowledge or skill gives misleading information with an intention of inducing the other party into entering into a contract, he is under a duty to use reasonable care to make sure the information is correct.
Yes.
From the facts of this case, Mandela maintained that he is not a bike expert and that he genuinely believed the bike to be a limited edition. However, my lord, common sense would dictate that if somebody has been cycling for so many years that they now wish to retire, the evidence would allow us to conclude that they must have acquired a sufficient mental skill or sufficient knowledge to distinguish the difference between a limited edition bike and one which is not.
Counsel,
Yes, ma'am.
on that point, are you saying then that there is no difference that Mr. Mandela is selling the bike in an offhand way in the back of the newspaper rather than selling it over the counter of a bike store? There's no distinction to be drawn there.
My lord, the point I'm trying to make is that the fact that he's been a cyclist for certain amounts of years, even though he doesn't claim to be an avid cyclist, he should still be in a position to at least find out whether he can advertise the bike as a limited edition.
Counsel, in answer to my question, so there's no obligation that he has to be holding himself out as having special knowledge or skill, simply such that he has that special knowledge or skill.
My lord, can I refer you to the case of Stephen and Rogers? It interpreted section 14, subsection 2 of the Sale of Goods Act.
Yes.
That act, my lord, establishes that whether a person is acting under normal business transactions or as a individual dealer, the moment he advertises a product for sale, he comes under the commercial transactions. Therefore, he would be obliged to give the correct information.
Yes.
Does that answer your question?
Yes, thank you, Counsel.
I am obliged. This point was re-emphasised by Lord Denning in the case of SO Petroleum and Marden which can be found in the Queen's Bench Division, page 801, year 1976, which can be found in your body, my lord, under page 135.
Yes, I have that.
I am obliged. In this case, Lord Denning stated that a person is under a duty to use reasonable care to see that the representation is correct and that the advice, information, or opinion is reliable. In this case, it can be assumed that where one party intends to sell a bicycle, they have a duty to give accurate information to any potential buyer who shows an interest. My lord, moving on to my third submission.
Yes.
It is submitted under Section 2, subsection 1 of the Misrepresentation Act 1967, where a person has entered into a contract after a misrepresentation has been made by him to another party, thereto, and as a result thereof, he has suffered loss, then if the person making the misrepresentation would be liable to damages, in respect thereof, had the misrepresentation been made fraudulently, that a person shall be so liable, notwithstanding that the misrepresentation had been made fraudulently, was not made fraudulently, unless he had reasonable ground to believe, and did believe, up to the time of the contract, that the facts represented were true. The respondents may try to argue that the statement was an innocent misrepresentation, as there was no proof of reasonable grounds. However, in this case, there is no evidence which directs us to conclude that Mandela believed his own statement, my lord. It is a well-known fact that products which are labelled as limited edition tend to hold more value than products which are not. Therefore, it would be within Mandela's best interest to shut his eyes and blindly state that the bike was a limited edition when in fact it was not, my lord. Mandela's statement was therefore made without reasonable ground for belief, thus holding it to be a negligent misrepresentation. In conclusion, my lord, if there has been a false statement of fact which was made with no reasonable grounds of its truth, and as a result induced my client to enter into the contract, I would seek your lordship to award my client with the reward of rescission. Would it not be absurd if we allow perpetrators to create alluring adverts to deceive the consumer? The aim of contracts, Lord, my lord, is to protect the vulnerable party, and if there has been a negligent misrepresentation, the aim of the remedy is to put the appellants back in the position in which they would have been in before they entered the contract. Unless I can be of further assistance to you, my lord, those are my submissions.
No, thank you, counsel.
And
Yes.
My name is Chris Bravin, and I am the junior representative for the respondent. I will be arguing that the decision of Lord Justice Sterling be upheld for 3 points. Firstly, I will be stating that my client did not make a misstatement of fact. And for this, I will be distinguishing this current case from the case of SO Petroleum, which is regularly referred to in cases of misrepresentation. Then I would be looking at 2 other cases in order to demonstrate that even if there was indeed a misrepresentation, Mr. Gandhi will not be able to receive any damages. So I'll now proceed with my first argument. It's been made clear up to this point that my client is not an expert on the subject of bikes. What's important here is not the amount of time that he spent riding his bicycle, is that he never actually claimed to be an expert. This is where the case of SO Petroleum is important, because it is clearly stated, you will find the pink tab in your bundle. The relevant section is highlighted by the orange marker, which clearly states, yes, you are, we should say, the layman. With all due respect, we are the experts. This amounts to a clear statement on one side that they are claiming to be experts. It must also be noted that in the case of SO Petroleum, we were dealing with two parties who had a certain amount of knowledge in that specific field. Yet, one party clearly said, I have more experience in this field. Therefore, I would like to distinguish that case from ours, since my client never actually said that he knew anything better about bikes than Mr. Gandhi.
Counsel, pausing there, you say your counsel doesn't hold himself out as knowing more about
Exactly.
Yes, that's perfectly true with the facts, but he does state that it is a limited edition bike.
I would like to...
Does that not imply that he knows or has some special reason to know that it's a special edition bike?
I will be addressing that issue later on.
Yes, Counsel.
This also relates to the point of inducement. Inducement is an important point when dealing with misrepresentation. However, in our case, we're dealing with a novice here. Mr. Gandhi doesn't know anything about bikes. He says it himself. This is clear from the facts of the case. So, could it really be said that the fact that the bike was a limited edition induced him to purchase that bike? There's no evidence to demonstrate that he was specifically looking for this type of bike. Even if my client had made a misstatement, even if my client had misrepresented the product, would this really have an impact on someone who had no idea what a limited edition bike was?
Well, Counsel, is the impact not represented by the difference in cost between £500 bike and £900?
Your Lordship is correct. There's a difference of cost. But still, in relating to the issue of misstating the product, my client didn't, I believe, hold himself out as being an expert.
Yes.
I will now move on to my second point, which is that even if there was a misrepresentation, Mr. Gandhi never took time to inspect the bike. Now this is clear from the facts of the case. Never was there a point when Mr. Gandhi went and inspected the bike. He had a lot of time to do this. He could have done it. He didn't. This relates to the case of Horsfall and Thomas, which is reported in the English reports, number 158, 813. It is in your bundle under the green tab.
Yes.
Basically, it was stated in this case that if there was an attempt to conceal a misrepresentation, if the claimant did not go and inspect, this could not have had an effect on the claimant's mind. Therefore, there was no misrepresentation. Now, this is important in our case for 2 points. First of all, we know, this has been said many times, Mr. Gandhi is a novice. He doesn't know anything about bikes. If he really didn't know anything about bikes, it is in his best interest to inspect the product which is being sold to him. We talked about the issue of cost earlier. There is a difference in cost between a limited edition and a normal bike. If there is such a difference between these two prices, it is in the best interest of the buyer to go and inspect the product before purchasing. This relates to a second point. It was made clear in the facts of the case that Mr. Gandhi actually has a friend who claims to be an expert on bikes. And apparently it seems very simple to ascertain whether or not a bike is indeed limited edition. It would have been very simple for Mr. Gandhi to ask his friend, I believe her name is Teresa, to inspect the bike, to ascertain that this bike is indeed a limited edition.
Counsel, my correct understanding of your argument is that the onus should be placed on the appellant to inspect and to take the reasonable efforts rather than the person making the representation or not, as you say.
Well, since there is an issue of cost here, and possibly the buyer would be curious as to differences in cost between a limited edition and a standard bike, he might want further information and he want to confirm that the bike that's being sold to him is actually a limited edition one.
Counsel, what distinguishes this case from the case where a person walks into a shop and sees a bike which is mislabeled and takes it to the counter? Where is the distinction? I'm trying to get down to the nub of your argument.
Well, the distinction in this case, my lord, would be that Mr. Gandhi had the opportunity to look for that information. He had all the elements to help him, and yet he did not take the adequate steps to do so. Finally, I would like to move on to my third point, which also relates to the Misrepresentation Act 1967. As was clearly stated by my learned friends opposite, all that is required for innocence is proof of reasonable grounds. Now, this question of is it reasonable or not for Mr. Mandela to know if his bike was indeed limited edition or not, this is what comes into question. Apparently, according to the facts of the case, the only issue, the only element which distinguishes a limited edition bike from a regular one is the color. This is a very simple fact. This is something which is very easy to ascertain and to confirm. Yet, the whole time that the bike was in Mr. Mandela's possession, he never once confirmed this, never even tried to do so. Nothing in the facts of the case states that my client made any kind of positive steps to ascertain whether or not his bike was indeed limited edition. This would confirm the idea that my client firmly believed that his bike was limited edition.
Yes.
In conclusion, I believe the ruling of Justice Sterling should be upheld, and unless I can be of any further assistance,
No, thank you, Councillor.
that is my submission.
Thank you.
Okay,
Okay,
his
thank you.
Lordship will now retire for his judgments. Court rise.